So the first question that we need to ask ourselves is, why is it important to know anything about the formation and the incorporation and registration of a company? So the first important thing is that incorporation and registration creates a juristic person with separate legal personality. And for our purposes, we're dealing with a Companies Act, so we're dealing with companies, and a company is deemed to come into existence from the effective date set out on the registration certificate. Then the second point is the importance of the Memorandum of Incorporation. So by now you know that the MOI is the sole governing document of the company. And during the incorporation process, the Memorandum of Incorporation for the specific company is drafted. It can be a standard form MOI, it can be a unique Memorandum of Incorporation drafted specifically to meet the needs of the entrepreneurs who want to start this company. And there can also be ring-fenced provisions in the MOI, and we're going to look at that a bit later. Then there is a formal process involved, and that means that you have to follow this process in order to create a new juristic person. And it's not just the incorporators who are involved. So the incorporators are the people who draft the Memorandum of Incorporation and give the Notice of Incorporation together with the MOI to the CIPC. The CIPC is also involved. They do the registration process where they enter the name of the company into the company's register. Then when it comes to creation, you also have to keep the operation of the company in mind. So think, what is the purpose of this company and what are the needs that I want this company to serve? Because the company is first and foremostly a business form. The Memorandum of Incorporation is very important for the formation because that sets the foundation for how this particular company will function. And it's important to know that the incorporators become the first directors. When you look at the incorporation process, there are three basic steps. The first step is for the incorporators to draft the Memorandum of Incorporation. And when they do that, they need to keep the type of company that they want to create in mind. So, for example, if you want to create a private company, there needs to be certain provisions in the MOI. If you want to create a personal liability company, you need to clearly state that it will be a personal liability company. But then in line with the aim of the Companies Act to be more flexible, the Memorandum of Incorporation can make provision for the specific needs of the entrepreneurs. So you will see we're going to look at the Memorandum of Incorporation in much more detail at a later stage, but there are a number of provisions that can be included in the MOI. Number one, if there are alterable provisions in the Companies Act. So for example, if there is a default provision in the Companies Act, but the Companies Act makes provision for this to change, then the change can be incorporated into the Memorandum of Incorporation. Then there are also things that the Companies Act might not deal with at all, and those things the MOI of a specific company can regulate. I've already spoken about the alterable and the unalterable provisions, and the Memorandum of Incorporation, the drafters need to be very careful that they only change alterable provisions and not unalterable provisions, because as you will see, any provision in the MOI that is in contrast or does not align with the Companies Act, and I'm going to show you the specific wording of the legislation, those provisions are void to the extent of the inconsistency with the Companies Act. And then if there are certain ring-fenced provisions that the incorporators want to ring-fence in the MOI, they need to do that. Then you get the completion of the Notice of Incorporation. So I'm going to show you an example of how it looks. The name of the company and the name of the incorporators and their signatures appear on the Notice of Incorporation. And if there are any ring-fence provisions in the Memorandum of Incorporation, the Notice of Incorporation need to point these out. Then step 3 is that the prescribed fee needs to be paid, and you can find the prescribed documents, forms, and fees at this particular website. It's from the CIPC, and then the documents need to be filed with the CIPC, the Companies and Intellectual Properties Commission. Now, we've looked at the incorporators that need to draft and sign the Memorandum of Incorporation. Then you need to file the Notice of Incorporation and the Memorandum of Incorporation and pay the necessary fee. And then you get to the registration process. And the registration process, that's basically undertaken by the CIPC. So that is where the particular company is provided with a registration number. The company's name is entered into the company's register. The Notice of Incorporation and the Memorandum of Incorporation is endorsed by the CIPC, and the registration certificate is given to the particular incorporators, who are now also the directors. It's very important to know that the company needs to put its name and registration number on all notices, official publications, letters, invoices, etc. And non-compliance with this requirement is an offence. So it's quite important to make sure that the name and the registration number of the company appears on communications. So what's the role of the CIPC? Now, the CIPC needs to check the documentation submitted, and then it can accept or reject the application for the registration of the company. It's important to note that under the 2008 Act, people have a right to incorporate and register a company. But there are some instances where the CIPC can reject such an application, and that is where there was non-compliance with the provisions of the legislation to incorporate and register a particular company. Now, there are two instances where the CIPC must reject the application for registration. So that is where the number of directors is not enough. So you'll remember you need 1 director for a private company, you need 3 directors for a non-profit company. And if there are not enough prospective directors, then the particular application must be rejected. And the same thing goes if some of the directors are disqualified from being directors. And we're going to look at the disqualification criteria for directors, but the number of remaining directors, so if you don't count the directors who are disqualified, the number of remaining directors need to be enough to meet the requirements of the legislation. And if that's not the case, then the CIPC must reject this application. But then there are instances where, notwithstanding that there was not specific compliance with the legislative provisions, the CIPC may still accept this particular application, or they may reject it. So if there's documentation that's incomplete or improperly completed, then in some instances the CIPC can still accept this application. And the approach that's followed here is substance over form. So as long as the necessary information is there, then this particular application can still be accepted. And the example used here is the name. So there are a number of restrictions on names. So you can, for example, not have a name that can cause confusion or falsely mislead people to think that this particular company is associated with a specific person or another company. Or there can be a request for a name that already exists. So in that case, the particular application will not be automatically rejected. What the CIPC will do is they will use the registration number of the company as the name of the company and just add the abbreviation. And in that way, the company is still registered, but the name is the registration number and then the necessary abbreviation at the end. Now, there are some specific requirements for company names, And Kasim, for example, argues that this is to protect intellectual property rights and goodwill, etc. Now, if a name is the same or confusingly similar to existing names or trademarks, or falsely imply or reasonably mislead people to think that this particular company might be associated with another company or person, then this will perhaps be a misleading or a deceptive name. You can also have unsuitable, inappropriate names, so names that are hateful, offensive, or unconstitutional. Now, let's take an example of a falsely misleading name. Let's say a company wants to start a swim school and they call the company the Ryk Neethling Swim School Company. And one day Ryk Neethling is invited to speak at the swim school and he has never heard of this swim school before. So the use of his particular name, it can be argued that this falsely implies that the company is associated with a particular person, where in fact it is not. And that is a situation where the name of the company will not meet the requirements set out in the Companies Act. Now let's have a look at the requirements for the names of a particular company. And you only need to know the basic requirements set out or highlighted in this slide and in the next slide. So the name of the company can be in words of any language. You can use letters and numbers. You can use the registration number if it's a profit company, and then what will usually happen is that the abbreviation and then in brackets South Africa will be put next to the name of the company. So the name doesn't have to be in words, it can also be the registration number of the company. It can contain punctuation, it can contain symbols, the Arabic alphabet, Roman numerals, etc. Just take note there are certain regulations pertaining to the names of companies. We're not going to go into those regulations in detail, but it is important that you take note of these regulations. So when it comes to the names of a company, it's important to make sure that the correct expression is set out at the end of the name of the particular company, so whether it's Pty Limited, etc. If there's a problem with a company's name, then the Companies Act makes provision that the registration number that's given by the CIPC to that particular company can also be used as its name. And then if you use the registration number for a profit company, so this isn't applicable to a non-profit company, then the words South Africa needs to appear in brackets after the registration number, and obviously the abbreviation setting out the type of company. So this is one of the ways in which there's more simplicity and flexibility written into the Companies Act, so that if there's an issue with a name, it's not going to affect the registration of the company. So just remember, a company has a name and a registration number. And if there is an issue with the name, and this can also be the interim name of the company, it will be the registration number as the name, but the registration number will also still be the registration number of that particular company. Now, what happens if someone wants to register a company's name and that name is confusingly similar or implies a non-existent association with someone else? So, for example, the name of the company is the next step in Nike evolvement, or the company is the Ryk Neethling Swim School. So the Nike example can be confusingly similar to the existing company Nike, and the non-existent association is where someone starts a swim school and it's implied that there's a link with Ryk Neethling, which there isn't. Then the company's commission can send a copy of this application for the registration of the company to people who the company's commission thinks have an interest in this particular name. So they can, for example, send it to the Nike company to just find out what the approach of that particular company would be. So people who have an interest in that particular name. If the particular name is offensive or unconstitutional, then the Companies Commission can send this to the South African Human Rights Commission. And at the end of the day, if there are any disputes about the name of a company, it can be referred to the Companies Tribunal. The Companies Tribunal is then the forum that will decide on any dispute pertaining to the name of a company. Now, a company can change its name later on, and to do that, the company will first need the permission, if I can put it like that, from the shareholders. And the shareholders must vote, and there must be a special resolution, and that means that 75% of the holders of voting rights approve of this name change. But then there's also a process to follow. So you need to send a notice of amendment to the Companies and Intellectual Properties Commission, and then they will provide you with an amended registration certificate and also amend the name of the company in the register. Now, when it comes to choosing names, it is permitted to reserve names, and there's a certain time period in which people can reserve names for a particular company. So for example, if you aim to incorporate a company in future and you want to make sure that no one uses a particular name during the time between, starting to draft the necessary documentation, actually sending it to the CIPC, then you can use a reserved name. And this is permitted, but just take note that this reservation cannot be abused. So people cannot, for example, reserve a couple of names and then allow people to use these names against the payment of a fee. What you also get is the registration of a defensive name. So that is usually when people have a direct and material interest in a particular name, then they can register that name as a defensive name. Like I indicated, the company needs to make sure that the name and the registration number appears on publications and correspondence. And it's also important to know that if a company trades under a specific name, then that name needs to be registered under the Consumer Protection Act. So the MOI as the governing document can regulate a number of things. Here are a couple of examples. So it can deal with the securities that the company can issue. It can deal with the powers of the directors, the rights of the shareholders. It can govern internal aspects like meetings and certain voting aspects. So there are quite a number of things that the MOI can regulate. As I indicated earlier, when you draft your memorandum of incorporation, you can either draft your own unique form or you can use standard forms that are referred to as COR forms and that you can find on the CIPC's website. They are also prescribed by the Minister in terms of regulation, so they can be used. Now let's just talk a bit about the amending of the Memorandum of Incorporation again. Now, when there is a need to amend the Memorandum of Incorporation, the Board of Directors can propose that the shareholders vote on a particular change, or 10% of the holders of voting rights can ask for a special resolution to be taken by the shareholders pertaining to this particular amendment. And then, of course, as I indicated, you need to file your notice of amendment. But what is the problem, or what is the process when you just have clear errors, mistakes that need to be fixed? And in those circumstances, under those circumstances, you do not need the special resolution. You can just file the notice of alteration. But it's important to note this is not an amendment of the Memorandum of Incorporation. It's just a process to fix clear and obvious errors in the Memorandum of Incorporation. This is the first part of the standard MOI for a private company, and I've extracted some paragraphs from the MOI. You will see that on the next slide. So this comes from the forms published on the website of the CIPC, that website that I referred you to earlier. So as you can see here, the MOI makes provision for the name of the company, the number of directors, and the alternate directors. We're going to look at that when we look at directors. Also remember that if you have a public company, your minimum directors are the number that you need over and above those required to comply with specific provisions of the Companies Act, like to appoint an audit committee or a social and ethics committee. So we are going to look at the audit committee and the social and ethics committee in more detail later on, but for now just know that those committees are but two examples where you might need more directors or directors with specific qualifications or specific types of directors to also be able to serve on those committees. Right, so this is two extracts from the standard form regarding to a private company. So what you will see here is the incorporation as a private company, and it is also set out the basic governing provisions pertaining to the particular company. Then if you look at the second part that deals with securities of the company, and you will see that it specifically restricts the company's ability to make an offer to the public of any of its securities. However, at some stage, one will also have to say something about restricting the transferability of the securities, because the legislation specifically refers to the fact that not only must the securities not be offered to the public, but the securities must also not be freely transferable. So after you've looked at section 19, you should be able to explain to me what the powers and the capacity of a company is. So you should be able to tell me that a company has all the powers and capacity of a natural person, except insofar as the nature of a juristic person limits that. So a company cannot get married, for example. Then you should know that a juristic person exists from the time that it's registered until the time that it's deregistered, and that the debts of a company belong to the company, and it doesn't accrue to a natural person unless, of course, there are certain provisions in the legislation or in the memorandum of incorporation that determines otherwise. So with regards to the MOI, you will see that there are certain provisions pertaining to a personal liability company where liability accrues to a natural person. Then a company is created in line with certain provisions in the Companies Act that have to apply to that particular company, and certain provisions that don't need to apply, that can be changed by the Memorandum of Incorporation. And then there can also be other provisions that the Memorandum of Incorporation regulates. So in the next slide, I'm going to look at a couple of examples of unalterable and alterable provisions. So let's have a look at the content of the MOI. Now, the Companies Act provides in section 15 that each provision of a company's memorandum of incorporation must be consistent with this act and is void to the extent that it contravenes or is inconsistent with this act. So the legislation clearly provides that inconsistency or contravention of the legislation, if you have a provision to this extent, that particular provision will be void. However, what section 6 subsection 15 says that if there is a specific content required by a particular public regulation, so a legislative rule, or by a listing requirement of an exchange, so let's say the rules of the Johannesburg Stock Exchange, and that has the effect that an unalterable provision of the Act is, for example, limited, then you should not see that particular provision as being contrary to section 15(1)(a). So if there is a particular provision that must be in a particular company's MOI because of a public regulation or the rules of an exchange, or the listing requirements of an exchange, then that is not going to be a particular provision that is inconsistent with the legislation. Now, the memorandum of incorporation of a company can deal with any matter that the Act does not address. It can alter any provision of the Companies Act, or if there is an unalterable provision. So remember, unalterable provisions may not be changed in a memorandum of incorporation. However, the exception is that if the company's MOI imposes a higher standard, greater restriction, a longer period of time, or a more onerous requirement, then that particular provision will be allowed, because it doesn't change the unalterable provision, it just raises the benchmark for that particular aspect. Here are a couple of examples of unalterable and alterable provisions. And the definitions for unalterable and alterable provisions can be found in Section 1 of the Companies Act, and you need to go and read and highlight those definitions. Now, Section 71 is an example of an unalterable provision. It starts by saying that despite anything to the contrary. So it basically tells you that the provisions of Section 71(7) will apply notwithstanding anything to the contrary, any other type of arrangement in another document. And what Section 71(1) basically focuses on is the type of resolution that you need in order to remove a director from its position. And that is an ordinary resolution. So it's 50% plus 1. And this basically says that you cannot raise the resolution percentage any higher. You have to stick to 50% plus 1. But then you get provisions such as Section 69 and 64, which tells you the following. In addition to the provisions of this section, the memorandum of incorporation of a company may impose these additional aspects. So it tells you that the memorandum of incorporation can put additional or extra requirements for a particular company into the memorandum of incorporation. So when it comes to disqualifications of directors or things like that. Okay, so that's an example where the MOI can actually add to the provisions of the Companies Act. And then you get Section 64, which says unless the company's MOI or rules provide otherwise. So that basically tells you that unless you change something for your particular company, this is the default position that will apply. So you don't need to know the content of these three sections now. We're going to focus a lot on Section 71 when we get to directors, but I want you to have a look at the wording of the sections that give you an idea of when you can or cannot change something, or where you can add to something in the MOI. Now let's have a look at an unalterable and an alterable provision. Now let's have a look at Section 65(8). Now that says, except for an ordinary resolution for the removal of a director under Section 71, a company's memorandum of incorporation may require a higher percentage of voting rights to approve an ordinary resolution, or one or more higher percentages of voting rights to approve ordinary resolutions concerning one or more particular matters respectively, provided that there must at all times be a margin of at least 10 percentage points between the highest established requirement for approval of an ordinary resolution on any matter and the lowest established requirement for approval of a special resolution on any matter. Okay, what does this mean? It basically gives the company the ability, or the incorporators the ability, to determine in the company's memorandum of incorporation a higher percentage for an ordinary resolution. So what is an ordinary resolution? Basically, it's 50% plus 1, so it's more than 50%. But A company can decide that an ordinary resolution for purposes of that company is 60%. Or if the Companies Act says that if you want to take this decision, you need to take an ordinary resolution. If you have to take that decision, you have to use an ordinary resolution. The Memorandum of Incorporation can determine different voting rights for specific ordinary resolutions of different aspects. So you can say if you take this decision, it needs to be 60% for that ordinary resolution. Or if you take that decision, it has to be 65% for that particular ordinary resolution. However, there must always be a 10% difference between your ordinary resolution and your special resolution. So however you move the percentages of your ordinary resolution or how you move the percentages of your special resolution, there must always be a 10% difference between the two. Okay, so that is a eligible provision, but there's a little limitation on the eligible provision. It has to have a 10% percentage point difference. Now then you get the provision where it says that despite anything to the contrary in a company's memorandum of incorporation or rules, or any agreement between a company and a director or between any shareholders and a director may be removed by an ordinary resolution adopted at a shareholders meeting by the persons entitled to exercise voting rights in an election of that director. Alright, so what does this mean? If you read this in conjunction with the first part of section 65, except for an ordinary resolution for the removal of a director under section 71. This basically means that an ordinary resolution is needed to remove a director, and that ordinary resolution has to remain at 50% plus 1. You are not allowed to raise the particular percentage of voting rights when you want to remove a director. And the reason is that when a director is removed by the shareholders, the higher the requirement to remove the director, the more difficult it becomes to remove that director. So the higher the particular percentage points become, the more difficult it is for the shareholders, and the argument is the more protected the particular director is. And that is not always in the best interests of the company. Right, so let's have a look at the instances or what happens if you change a particular resolution. So I'm just going to focus on the ordinary resolution for now. So we know that the normal basic ordinary resolution is 50% plus 1. But let's say we change that to 65%. That will still be acceptable if we don't change the 75% for special resolution. If we leave the 75% of the special resolution as it is, then there's a 10% between 65 and 75, so the highest for the ordinary resolution and the lowest for the special resolution, and this is perfectly in order. The problem comes in if you decide that you want your ordinary resolution to be 70%, but you do not change anything in your special resolution, then there's only 5% between your ordinary resolution and your special resolution, and that will not be acceptable. But just remember, this is not applicable to your removal of the director. The director's removal percentage has to stay at 50% plus 1. There is a specific provision in the Companies Act that we call the anti-avoidance provisions, and is basically there to give the court certain powers to deal with provisions in a company's memorandum of incorporation or the rules of a company or certain agreements that basically tries to circumvent the prohibition or the limitations brought about by an unalterable provision. Now, a court can declare any agreement, transaction, arrangement, resolution provision of an MOI or rules of a company that have a specific nature, so it is primarily or substantially intended to defeat or reduce the effect of the prohibition or requirement established by or in terms of an unalterable provision of this Act. So it's basically a provision or an agreement that tries to circumvent a the effect or the purpose of an unalterable provision. And it gives the court the power to declare that particular agreement, provision, or rule void to the extent that it defeats or reduces the effect of the prohibition or requirement established by or in terms of an unalterable provision of this Act. Now, it's very important to note the following. If the Act says that a specific provision or a rule or something like that is void, then it is void ab initio. But if the Act just says that it is prohibited, then you need a declaration by the court that that provision is actually void, or in some instances even voidable. But if the Act doesn't particularly state that something is void, you will need a declaration by the court. There's also a provision in the second part of the anti-avoidance provision, which says that a person can apply to the company's tribunal to exempt an agreement, transaction, arrangement, resolution, or a provision of a company's memorandum of incorporation or rules from a prohibition that is set in terms of an unalterable provision. And then the Companies Act can make an order that basically exempts this particular provision from being a defeating or a reduction in the effect of this prohibition requirement. And the tribunal can do this if it thinks that the purpose of this particular agreement is a reasonable purpose, and that the purpose is not to defeat or reduce the effect of that prohibition or requirement. So it has another purpose, and that it is reasonable and justifiable to grant the exemption if you look at the purposes of this Act and other relevant factors. So for example, if you look at why this particular prohibition or requirement is in place in the first place. So let's say, think for example of section 71. So the purpose there is to protect the company so that the company can get rid of directors that do not do their jobs. You can look at the extent to which the agreement or the provision infringes a relevant prohibition or requirement. So sometimes the agreement doesn't have a very big effect on the prohibition. So I don't think that the court would or the tribunal would easily exempt a provision that says that the percentage needed to remove a director is higher, because that is going to have such a huge effect on the prohibition, and I can't really think of any other reasonable purpose that it would serve. But you can have instances where there is another purpose, not the first purpose of the particular provision is not to defeat or reduce the effects of a prohibition, and it's reasonable and justifiable for the tribunal to exempt this particular provision. So what's the gist of the matter? If there are certain provisions or agreements that try to circumvent the legislation, then the court has certain powers to declare it void to the extent that it defeats or reduces the effect of a particular prohibition or requirement, and specifically regarding an unalterable provision. But then there's also a provision where the tribunal can exempt this particular provision based on the grounds that we've just discussed. The Companies Act makes provision for the creation of ring-fenced companies. Now, a ring-fenced company is not a new or a different type of company. It is something that applies to a particular company due to something that's in that particular company's memorandum of incorporation. So you can have a ring-fenced private company, a ring-fenced public company, etc. Now, how this works is that if there is a restriction in a company's memorandum of incorporation, so let's take the following example. Section 66 determines that the board of directors, so all the directors acting as the board of directors, the board has the authority to exercise all of the powers and perform any of the functions of the company. So the board automatically has the authority to represent the company. The single directors, however, they do not have this automatic authority. It has to be the board of directors. But what the memorandum of incorporation can do is that it can alter this alterable provision, because as you can see at the end of this section it says, except to the extent that this act or the company's memorandum of incorporation provides otherwise. So this this particular authority of the board can be changed. So let's say there is a provision in the memorandum of incorporation that says that the managing director has the authority to enter into contracts on behalf of the company. That is a restrictive provision. But then together with this restrictive provision, there needs to be an above average requirement for amendment. Now, normally to amend your memorandum of incorporation, you need 75% of the holders of the voting rights. So those shareholders, they have to vote yes to amend the memorandum of incorporation. But what you can do is you can add an additional requirement. So say, for example, all the directors together with the shareholders need to approve this amendment. So if there is an amendment to this particular provision that the managing director can enter into contracts, then you have to comply with these additional requirements in order to amend that provision. Now that restrictive provision coupled with the additional requirements for amendment, that can result in a company qualifying to be a ring-fenced company. And that particular provision will then be ring-fenced if the following steps are taken. Number one, the notice of incorporation must clearly point out that this is a ring-fenced provision, and it also has to indicate where in the memorandum of incorporation this restrictive provision together with the requirement for amendment can be found. So for example, paragraph 2.2 or 2.3. Then, immediately after the company name, the initials RF need to appear. So the company would be, as that example right below, ABC RF Pty Limited. And that indicates to third parties that this is a ring-fenced company and that there is a specific provision or provisions that have been ring-fenced. Now, the additional type of provision that can be ring-fenced is where there is a specific provision coupled with a complete prohibition on amendment. So that is where you say this company can only trade in vehicles and this particular provision may never be changed. So there's a prohibition on the amendment of a specific provision, and then the notice of incorporation must clearly point this out and state where in the memorandum you find this provision that is prohibited from being amended. And after the company name, you have to put the initials RF or the abbreviation RF. And then a particular company will be called a ring-fenced company. So you have to follow all these steps. There needs to be provisions that qualify, and those provisions are in the MOI. The notice must point this out, tell you where to find it, and RF needs to appear after the name of the company. And where a company is ring-fenced, the doctrine of constructive notice will apply to those ring-fenced provisions. And we're going to look at the doctrine of constructive notice. Now, the doctrine of constructive notice basically comes from the pre-2008 position, and before 2008 the doctrine of constructive notice basically applied across the board. However, this position was expressly changed in the 2008 Act, so the opposite position basically now applies. The doctrine of constructive notice does not apply to the position that we are in now, but there are a couple of exceptions. Okay, so what is the doctrine of constructive notice? It was basically a rule that said if a particular document was available to the public, then someone who contracted with the company was deemed to have knowledge of that particular document's content. So, for example, the Memorandum of Incorporation, so under the pre-2008 dispensation, it was your Articles of Association and your Constitution. Those documents were open for inspection and you could have access to them. And then before you contracted with a company, the duty was on you to make sure that you read those documents and that you were familiar with the contents. It was not an excuse to say, but I did not know, because you were deemed to have knowledge because you had access to those documents. But now, under the 2008 Act, Section 19, subsection 4, so by now you guys must know that Section 19 is an extremely important section when it comes to companies. It tells you what a company's legal status is. It tells you about the liability of a person, liability company's directors. It tells you about the doctrine of constructive notice. Okay, so what does Section 19, subsection 4 say? It says that a person must not be regarded as having received notice or knowledge of the contents of any document relating to a company merely because the document has been filed or is accessible for inspection at an office of the company. So when we look at the definition of the word file, then it means that you've sent it to the CIPC. So what does Section 19, subsection 4 say? Someone is not deemed to have information of the content of a document just because that document is accessible to that particular person. So just because that person has the opportunity to go and review those documents that are not internal private documents that are open for a person from the public to go and inspect, just because those documents are available, it does not automatically mean that this person should have knowledge of the information. Right, so if you did not read the Memorandum of Incorporation, you can say, but I did not know. However, there are restrictions or exceptions, and if you have these instances, then you are deemed to have knowledge, and they only apply in certain instances and in respect of certain information. So let's have a look at the ring-fenced company. Now, if there is a restriction, like I said, for example, only the managing director can contract on behalf of that company, and it is written into the company's Memorandum of Incorporation, there is an additional requirement for amendment. So it's not just the normal 75% special resolution to change the Memorandum of Incorporation. It's also something like all of the board members must agree and all of the shareholders must agree. Then, if the company draws this to the attention in the NOI, so it tells in the notice of incorporation, tells people that there is this restriction and says exactly where in the memorandum of incorporation this restriction can be found, and the letters RF appear in the name, then in respect of those restrictions, the doctrine of constructive notice will apply. Okay, so what's the benefit of this for a company? Let's take the example of the managing director. If someone who is not the managing director enters into a contract on behalf of the company, the company will not be bound by that contract because the representative did not have the authority to bind the company. The third party can also not come and say that the company made a representation that this person had the necessary authority, so ostensible authority and estoppel, because it clearly states in the MOI that only the managing director has the ability to enter into contracts. So the third party is deemed to have knowledge that only the managing director can enter into contracts. And if he enters into a contract in inverted commas, then he has only himself to blame. So that is a way in which the company is protected. But remember, the doctrine only applies in respect of those restrictions. So not the whole MOI, only those ring-fenced provisions, and only in respect to the extent that there was compliance with the legal requirements for a ring-fenced company. So, notice in the notice of incorporation pointed out where the provision was, letters RF after the name. And the same goes for certain provisions that prohibit amendments. Okay, the second instance is where you have an incorporated company, so where you have a personal liability company, and the doctrine of constructive notice basically applies to the effect of section 19.3. And what does section 19.3 say? It says that the past and present directors of the company are jointly and severally liable together with the company for the debts contracted during the term of their office. So section 19 subsection 5 says a person must be regarded as having notice and knowledge of any provision in a company's memorandum of incorporation if the company's name includes the element RF and the company's notice of incorporation or a subsequent notice of amendment has drawn attention to the relevant provision, and a person is regarded as having notice and knowledge of the effect of subsection 19, subsection 3 on a personal liability company. So the specific thing that a person is regarded as having knowledge and notice about is the fact that the directors are jointly and severally liable together with the company, like the provisions of section 19 subsection 3 indicates. Now this slide just sets out a couple of aspects pertaining to the memorandum of incorporation, the role of legislation, certain unique contents that can be contained in a memorandum of incorporation, and the effect of the memorandum of incorporation. We are going to look at the binding effect of the MOI and which persons are bound by the provisions of the MOI, and then we've already looked at constructive notice. Now, just one aspect. If the MOI is amended, one has to be very careful not to change it into a different kind of company. Because remember, there are certain restrictions on non-profit companies. There's a certain process needed for incorporated companies, so notice requirements. And if you change a private company to, for example, a public company, there are certain regulatory changes that will apply. Now, you can get a situation where neither the Companies Act nor the Memorandum of Incorporation deals with each and every aspect necessary for the directors to know how to run the business of the company. So the directors are authorized, or provision is made in the Companies Act, that the directors can make certain rules relating to the governance of the company. So those are aspects that are not dealt with in the Act or the Memorandum of Incorporation, and they are necessary or incidental to enable the directors to govern the company in a consistent manner. Now, the Memorandum of Incorporation can indicate that the directors may not make these rules, and the rules will always have to be in line with the Companies Act and the Memorandum of Incorporation. Otherwise, these rules will be void. Now, what is the binding effect of the rules of the directors? So the directors can make these rules, but then they have to file the rules with the Companies and Intellectual Properties Commission, and 10 business days after they filed it, it takes effect. Now, this is a way in which the Companies Act makes provision for some flexibility. The rules of the directors are binding until a general shareholders meeting is held. And then at the general shareholders meeting, the shareholders need to vote about the rules that were made. So in the interim, until the shareholders meeting takes place and it's voted, the rules are binding. And then if the shareholders agree and they vote yes, then those rules become binding. So what we actually say the shareholders do is that they ratify these rules. And notice of ratification also has to be filed, sent to the CIPC, and even if the shareholders do not vote yes at the meeting, so they say that they are not happy with the rules that the directors made, then this notice of non-ratification also needs to be sent to the CIPC. Now, nothing that the directors do in terms of the rules that they make in the interim time, even if the rules are not ratified by the shareholders, it doesn't affect anything that the directors did during this interim time that the rules were in place. But if the shareholders do not agree or ratify these rules, then the board may not make a similar rule for another 12 months. Okay, so that prohibits the situation where directors make rules, there's an interim binding period, then the shareholders vote no, they do not ratify it, and then the board just goes and makes exactly the same rule, and it's again binding for that for that interim period. So no, when the shareholders decide that they're not going to ratify particular rules, then the directors may not make these or similar rules for another 12 months. And you need an ordinary resolution by the shareholders before they can actually ratify a particular rule. So 50% plus 1. So what is the legal position when it comes to a company's memorandum of incorporation and any rules of the company? Okay, so the MOI and the rules of the company are binding between the company and each shareholder, between the shareholders of the company, and between the company and every director, prescribed officer, or any other person serving the company as a member of a committee of the board in the exercise of their respective functions within the company. Alright, now I'm going to show you in the next slide what these relations are, but just take note of the wording of section 15, subsection 6. So it's really important to know that the Memorandum of Incorporation and the rules are not binding on outsiders or third parties. So the provisions cannot be enforced against the company by third parties. So if you look at Kasim, she calls it a contract that derives its binding force from statute. And this is extremely important because there are certain people, if they do not act in the capacity of a director, a prescribed officer like the company secretary, a member of a committee of the board, so for example a member of the audit committee or a shareholder, then they cannot enforce the provisions of the MOI against the company. Now, it's only in respect of certain capacities. So if you are, for example, a shareholder, then you can enforce the provisions of the MOI against the company. So you can ask that the company basically honor the provisions of the Memorandum of Incorporation. But you cannot do that if you are a creditor. For example, let's say you loaned money to the company, not as a shareholder, but as a normal creditor. Then, even if you know about the provisions of the Memorandum of Incorporation, you cannot enforce the provisions of the MOI because you're not doing it in the capacity that binds the company to you. Now, let's take this example. Let's say the company appoints a shareholder's spouse as its attorney. Now, you are a shareholder, so you do know what the contents of the MOI is. And you know that there is a provision in the Memorandum of Incorporation that states that the attorney has to be appointed for 5 years. However, the actual contract, the agreement with your wife or your husband, that particular agreement says that the attorney can be fired on 1 month's notice. And this happens, so the agreement comes to an end before the 5 years. Now, the attorney, your spouse, cannot enforce this agreement against the company. So the attorney cannot come and say, but your MOI says that I have to be appointed for 5 years, because the attorney has no right to enforce the provisions of the MOI against the company because it doesn't bind, it doesn't constitute a contract between the company and the attorney. And the fact that the attorney knows about the provision in the MOI doesn't help him or her because the MOI is not binding between the company and the attorney. The attorney has no ground to say, but you have to follow the Memorandum of Incorporation. Well, Kasim argues that the right can be indirectly enforced. So let's say, for example, the shareholders find out that the company acted in contravention of the Memorandum of Incorporation. Then the shareholders can enforce the provisions of the MOI against the company because there is a binding agreement. The MOI binds the company and the shareholders. Now, let's take another example. The director can enforce the provisions of the MOI against the company, but only in respect of the capacity and the functions of the director. So again, if the director ended up being a creditor of the company or an attorney of the company and wants to enforce a provision of the Memorandum of Incorporation in his or her capacity as creditor, a right that he has as a creditor but not as a director, or a certain right or interest that he or she wants to enforce as an attorney and not as a director, then that will not be possible because the MOI doesn't bind the person in his or her capacity as a creditor or attorney, but only in the capacity as a director. Now, the shareholders of a company may enter into any agreement with one another concerning any matter relating to the company, but any such an agreement must be consistent with the Companies Act and the company's Memorandum of Incorporation. And if there's any provision in the agreement that is inconsistent with the Companies Act or the company's Memorandum of Incorporation, it will be void to the extent of the inconsistency. Now, the shareholder agreement is basically a private agreement between specific shareholders. It's not filed with the Companies and Intellectual Properties Commission, and it's not available for inspection. So the normal principles of law pertaining to contract apply to bind the shareholders, and also dictates the remedies available for the shareholders. And just like any contract, it only binds those who are a party of it. So if you want to include someone else in the agreement, then that person has to consent to it. And you cannot use a shareholder agreement to circumvent the provisions of the Act or the Memorandum of Incorporation. The result will be that any provision that contravenes the legislation or the MOI is void to the extent of the inconsistency. And then, of course, the anti-avoidance provisions can also apply. Let's have a look at the hierarchy of the specific documents, etc. So the Companies Act is the overarching legislation. So anything that contravenes or is inconsistent with the Companies Act will either be void as specifically indicated in the Companies Act, or if there is merely a prohibition, then the court can declare it void. Now, the Memorandum of Incorporation is the governing document of the company, but it has to be consistent with the Companies Act. So any provision, here we have a specific provision in the Companies Act that says that any provision of the MOI that is inconsistent with the Companies Act will be void to the extent of the inconsistency. Then you get directors' rules and shareholders' agreements, and the rules and the agreements must be consistent with the Memorandum of Incorporation and the Companies Act. So that is basically the hierarchy of documents and laws that applies to companies. Right, so let's have a look at a question. Now, this particular question is the following. The Memorandum of Incorporation of BPS Pty Limited contains the following clauses. So 1, 2, 3, 4, I've given you 4 clauses, and then I ask you discuss the validity and effect of these clauses. So it's about the content of the Memorandum of Incorporation. The first clause is a special resolution that has the meaning prescribed to it in the Act. The second one is an ordinary resolution that requires the support of shareholders holding at least 70% of the voting rights exercised on the matter. 3 is in order to increase the protection afforded, a special resolution is needed to remove a director, and then the company must at all times have 10 directors. This provision may only be amended if all the directors support the amendment, supported by a special resolution of the shareholders. And then I indicate to you that the Companies Act determines that a company's Memorandum of Incorporation may specify a higher number in substitution for the minimum number of directors required by subsection 2. Alright, so let's have a look at the answers. So if you follow the same approach to answering an application question, in order to make sure that you comprehensively answer the question, you need to take 4 steps. The first step is to identify the issue. The second step is to state the law. The third step is to apply the law to the facts. And the fourth step is to come to a conclusion. Now I'm asking you to discuss the validity and effect of each of the clauses. So that's basically the issue at hand. Now the first clause says a special resolution has the meaning prescribed to it in the Act. Now that will be 75%, and on face value there's no issue with that particular provision. So it will be valid and it will be of effect. Now let's have a look at clause number 2. An ordinary resolution requires the support of shareholders holding at least 70% of the voting rights exercised on the matter. Alright, so now we see that this is an instance where the percentage points for an ordinary resolution was changed. And again, if you only look at that clause in isolation, there is no problem, because the Companies Act clearly states in section 65(8) that the percentage needed for an ordinary resolution may be made higher. So the fact that it was changed is in itself not a problem. However, there is a second part of the provision that deals with an increase in the ordinary resolution. and that is that at all times there must be a 10% margin between the highest percentage needed for an ordinary resolution and the lowest percentage needed for a special resolution. So the moment that you look at clause 2 in the context of clause 1, you realize there's a problem because there's not 10% between 70 and 75. So this provision it's a rule in the Memorandum of Incorporation that contravenes the Act, and therefore that provision is void, and you will go back to the default position of 50% plus 1. Then let's have a look at number 3. In order to increase the protection afforded, a special resolution is needed to remove a director. Now, what is the issue? Section 71 says an ordinary resolution is needed to remove a director. It is an unalterable provision, and raising the percentage from 50% plus 1 to 75% is actually not more onerous, because why would the shareholders want to remove a director? Because they perhaps feel that the director is no longer doing a good job. And the more votes you need to remove the director, the more difficult it becomes to remove this director. So it actually doesn't protect the company, it protects the director. So clause number 3 will not be valid because it contravenes section 71. Then the last one is the company must at all times have 10 directors. And we know that the default position is that the Companies Act says 1 or 3 directors, but then gives the drafters of the MOI the freedom to change the number of directors, as that particular subsection that I quoted in the previous slide. Okay, so this is a restrictive provision because it changes a provision in the Companies Act. But then the next sentence says that this provision may only be amended if all the directors support the amendment, supported by a special resolution of the shareholders. So there is an additional requirement to amend this provision in the Memorandum of Incorporation, meaning that you also need the support of all the directors. So this is actually an RF company. It's valid, but the name should also indicate this for the Doctrine of Constructive Notice to apply, for example. So it'll have to be the BPS RF Pty Limited. Now, ideally, you also need the Notice of Incorporation to point this out and also to say that this is in clause 4 of the Memorandum of Incorporation.